I begin by acknowledging that we are gathered here today on the traditional and unceded territories of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. Those of us joining from throughout the province are similarly situated on traditional territories of Indigenous peoples, and no matter where we are, we acknowledge and appreciate the opportunity to gather on their lands. In doing so, we are mindful of the impact Canadian laws and policies have had on Indigenous peoples in our province, and as we consider the possibilities of how legal systems might change, we also must incorporate the laws of Indigenous peoples in this province. My name is Carey Simmons, and I am the Executive Director of the Canadian Bar Association BC branch. I'm here to welcome you on behalf of all the organizations who put this evening together. They include the Continuing Legal Education Society of BC, Access to Justice BC, the Law Society of British Columbia, the Law Foundation of BC, and the Courthouse Libraries. I'm very pleased to welcome all of you here tonight. This is the second annual Access to Justice Week in this province, and the Attorney General proclaimed this as such last week. The activities this week engage members of government, members of the broad legal profession, in which I include lawyers and judges and paralegals and community advocates. It includes the University of Victoria, the Allard School of Law, and Thompson Rivers University. And at each of those universities, we have hubs of law students who are joining us remotely, as well as members of the legal profession throughout the province. Everyone here is obviously interested in listening to our guest speaker tonight, Margaret Hagan. But I just wanted to take a moment to explain how people are connecting what she is going to talk to us about with the greater work that we are doing here in this province. Our Chief Justice, Robert Bowman, has said this week that the greatest needs exist in family and civil law, and because they affect so many people's day-to-day life and well-being, and attention needs to be paid to administrative tribunals as well. The impact on vulnerable people is tremendous, and those are the people we ought to have at the forefront of our considerations when trying to tackle the access to justice problem. Many of the organizations who worked together to bring this evening for you have all signed on to the Access to Justice Triple Aim, which commits how we view access to justice to three considerations. We need to have improved user experience of access to justice. We need to have improved population access. In other words, more people need to be able to access the system. And we must have an improved system of cost management and sustainability of a system that's going to work. So with all of those things in mind, things we have said we are going to do, we are pleased to introduce you to Professor Margaret Hagan, who comes to us from California. She has worked on projects all over the United States that are dedicated to trying to address those different needs. So we're here to learn from her about what she has observed as an academic, as a leader, as an innovator, and see what we can do to adapt those lessons to our own practices, to our own systems, and hopefully take away some good ideas that'll help us advance the work that we are trying to do here in this province. So thank you for coming here to see us. Please come up and take the floor.
Hi, everyone. So I'm Margaret. I'm looking forward to the Q&A. I'll have some remarks about my work and some changes in my work recently. Before I get into that, I'd love to know a little bit about who's in the room. Are there any law students or other students in the room today? Terrific. All right. How about practicing lawyers in the private bar, or who work for a government agency, or in the courts as court staff or judicial officials, or self-help, paralegals, law librarians, foundations or other funders, supporters? Oh, terrific. Anyone else who I'm missing? Academics like myself have anyone from the university? Great. Okay. Well, we'll all mix together. Anyone else I'm forgetting? Technologists, data folks? Graphic designers? Okay, great. Legal publishing. All right, the list goes on. Thank you. Well, that's helpful for me. Hopefully what I'll say today is relevant to you. I'll be talking a lot about my own work, so I'm happy always to geek out about that, but hopefully in Q&A we can make sure that what I care about is bridging to what you care about and the problems that you're trying to solve in your work and strategic networks. So the big challenge that has been motivating me in my work for the past 7 years, starting when I was a law student and after graduating, starting my lab at Stanford, has been about impact and the justice gap in the United States. How do we really make a difference on the numbers of people who can use the civil justice system to resolve their life problems and the quality of their experience and the substantive justice that they experience if they do end up in the court system? In the US, I'm sorry for the US focus, I'll just speak to what I know. I'm happy to bridge this in our Q&A to what's happening in this province or in Canada, but we know in the United States that there are huge numbers of legal needs, largely thanks to Becky Sandifer's work. Many of these, most of them are underserved, meaning people don't seek out help for them, or if they try to seek out help, they are not being served by legal aid or other public interest organizations. And that there are a large number of needs that are never even recognized as legal needs. So people are dealing with them on their own and not even getting government or public interest help to deal with them. So I'll talk through about, with this motivating question of closing that gap, of getting those numbers of underserved down or the numbers of problems that are resolved up. I'll talk through the 2 phases of work that I've gone through in my 6 years of running an innovation lab at a university. The first phase of bridging the world of human-centered design, which probably is familiar to most of you, especially being that that's part of the triple aim of the Access to Justice Network here, of bringing this design approach to the justice system, which was the focus of my work for the first 4 to 5 years of the lab, and is still kind of core to what I do and how I teach and how we do projects at my lab. But then the shift that we've made about 1.5 years ago to thinking in concert with that, how to be more strategic and think more at scale. I'll close with some thoughts about kind of international scale or how we might even think about a network between multiple countries. Some thoughts to then feed into the Q&A. So I'll talk for about 30, 35 minutes. If I go more than that, you can yell at me and I'll stop talking. So let me talk a little bit more about design and that approach for the justice system. Again, I'll get a feel of the room. So who here knows a great deal or a substantial deal about human-centered design? Am I speaking to a group who? All right, so mixed. Terrific. So I'll talk a little bit more about what the heck this jargon means and why I think there's value in it for those of us who work in the legal sector and justice sector. So like I said, I run a lab. I run an innovation lab at a university, which is a really wonderful job because I get to link together groups of people and ways of working that often have not been brought together beforehand. Universities are great for this. So the basic driving hypothesis of my lab when I started it in 2013 to 2014 was that lawyers shouldn't be the only types of professionals looking at legal problems or problems in access to justice. That in fact, we need to talk to people from, in my case, across campus. So going over to the computer science school, people who are in depth looking at emerging tech like AI and blockchain and data-driven solutions, but also more non-emerging tech like good applications and web design. Also talking to folks in the design school about how they solve problems, how they work, how they launch projects, how they bring diverse groups of stakeholders together to come up with solutions, and how we can bring to bear those methodologies and those ways of working from the worlds of design and the worlds of technology and CS and bring them to bear on the problems in the justice system. So that was the motivating factor of my lab. And now there are labs all over the place. So this is really interesting. Basically since 2015, we see an explosion of innovation labs, many of them titled explicitly labs, but others titled more informally, often at universities. So everywhere from the University of Melbourne to Brazil to Bogota, Colombia to Italy and Belgium and Finland, throughout Central America, a lot in the US, some in Canada. So labs where the driving focus is on how we make new kinds of legal services, especially in the public interest, how we leverage technology and other ways of working to solve these problems that lawyers and the justice system face. So it's very exciting. There's more people doing this, which means there's a lot more potential impact that we can have. And I think one of the frame that most of these labs are working around is taking what often we in legal world talk about on the right-hand side. How can we make the legal system more equitable, more accessible, more just, these values that motivate us, and bridging them to the folks across campus, the people from design and technology worlds. How do we make the legal system more usable, more engaging, more useful? And using a process, again, taken from, in my case, across campus, to come up with new solutions, to develop these new experiments, these new pilots, these new interventions that hopefully will make people's lives better in the justice system, where we go out and we talk to lots of people who often aren't usually included in decision-making processes, like litigants or defendants or their family members or frontline staff at courts or solo and small firm lawyers. What are your problems? What are you experiencing? What are you excited about to reform? Synthesizing those into coherent design briefs, and then going through a startup-like process of building new ideas in rough, quick, cheap ways, testing them in the field, using that testing to then inform where we should actually spend money and start scaling up pilots. What that also means is taking an approach to innovation in legal services that's much more community-centered, so letting a lot more and people from different points of view into these discussions about how we reform the justice system, and doing a lot more building. So less reports, less task force around a boardroom kind of conversations, and more workshops, more sprints, more hackathons, more building sessions to actually get forward motion on these great new ideas about technology or service innovation, and a commitment to experimentation and evidence-based policy making. So if we have great ideas, let's put it into the field and let's test them before we commit to pilots. What that looks like in practice. Let me just show you in pictures what human-centered design looks like, because it's better than me talking. So usually we start out with a project at my lab, especially in the model in my first phase, where we would work with our local courts, in my case, Santa Clara County Courts or San Mateo County Courts, so in downtown San Jose or in downtown Redwood City in California, if you've ever been there, and often with the statewide agency, the Judicial Council of California, that runs and funds most of the courts and self-help at the state level. So oftentimes, before we start a project, I just have lots of calls with the different judges who are interested in innovation, or the many leaders of our state agency who are interested in access to justice, to say, what are the big pressing problems that you wish you had a whole group of people working on with you? Where do you need capacity for innovation? So after those scouting calls, usually we would choose one of those ideas. So in the beginning, it was quite reactive to whatever the hot topic or the questions of the judicial leaders were. So in the past, we did lots of projects around language access. How in California can we make sure that people who do not speak English or Spanish have a really good and fully equitable experience at court? Or around guardianship. How do we make sure that a grandma whose daughter is in drug rehab, that she can get custody or guardianship of her grandchild so that the child can be enrolled in school and go to a doctor? So we would see these hot pressing problems, bring the group of students, always multidisciplinary, so a mix of law, CS, design, social science, policy students together to understand the court's point of view or the system owner's point of view, and then convene lots of people to talk about what might be possible and what's going wrong with the current system. So really hearing from litigants' point of view or frontline staff's point of view, what does your day look like? What does it look like to go through the court or to have a legal problem? How did this happen to you? What were the series of actions that you took? Where was it absolutely miserable? Where was it actually surprisingly easy? Where do you think we should spend resources to fix a dysfunction? Then we go out into the field and we do it ourselves. We play the role of litigant or even frontline staff, and we hang out at court. We sit in self-help centers. We try to observe with our firsthand experience. What are all the pieces of paper? Where are the signs? What does it smell like? Is there any air circulating here? Where are all the lines congregating? But to really get the on-the-ground feel of where dysfunctions might be. We do lots of exit interviews with people coming out of their hearings or coming out of self-help centers to hear about their procedural justice experience. Did you actually understand what just happened? Did you feel respected? Was your sense of dignity left intact or improved or harmed? We go through it ourselves. This is one of my students. I had him file for divorce, so he had to stand in all the lines, fill in all the paperwork, go through all of the intake interviews to really feel what it feels like to be a litigant. Then we start our synthesis. We do all of this gathering of information firsthand through interviews, other kinds of research. Then we map out where are there opportunities. And we do lots of mapping of the actual court experience too. This is one of my wonderful students' work in Boston housing court, of like the whole experience of coming to court, trying to find the right elevator, trying to find the right courtroom. And then we start to jump to where are there great ideas. Brainstorming, how would we make this place better, more usable, more useful, more engaging? And we come up with lots of ideas. We again try to do this with a mix of stakeholders where we have funders and legal aid lawyers and court staff mixed with actual litigants or criminal defendants to come up with ideas together and to reckon with each other's points of view about how to make something that would work for all of them. We come up with tons of ideas. We make these idea catalogs for any given problem, like for language access in the courts. What are the top 10 ideas of how we could improve language access in Santa Clara County Courthouse? And then we start voting. And again, we do this in a community-driven kind of way, where we bring together those stakeholders that we've been talking to understand their experience and have them vote on which ideas they think should actually go forward to pilot, which would be most valuable from their perspective. Then we start building and testing. It comes back into our lab, and we have small teams of students who are trained in technology or software or service development to actually work on building something to test it. And then we go to pilot, and hopefully with a randomized control or other empirical evaluation standard to really figure out if the thing works. So for example, we have lots of text message-based pilots going on right now with courts, court reminders or procedural coaches. Text messaging is really hot right now. People all like text messaging, so that's great. So that's the general life cycle of a human-centered design project with the courts. And if this tests well, let's say San Mateo Traffic Court, the hearing reminders work well, we might then scale that up to have more messages, not just hearing reminders, for example, but also surveys to hear about outcomes down the road or procedural justice surveys, or other kinds of coaches that can help them with other legal problems, but kind of developing relationships. So scaling from a single trial to have more services. Or we might try to get every single court in California to have a similar program to the one we've piloted if this proves to work well. So that's kind of the life cycle, and that's great. I mean, this project or this way of working, students really love it because they get to do hands-on work with real people in real contexts and what they came to law school for, helping people solve their problems and make a great legal system. And we figured out in these first 4 years that taking a design approach using that methodology can help a lot. It can produce all this new kinds of user research beyond just normal surveys. It can come up with principles and other guiding things to guide courts and self-help centers and legal aids about how to do better outreach, how to engage their public. It has a whole lot of ideas that comes out of it, so we have a big list of agenda of things to try out. So we figured out, yes, we can put users at the center. We can improve people's legal capabilities through these kinds of projects. And we can make things that are really good looking. We can make really beautiful websites, apps, documents. That's all wonderful. So I'm very happy that those things have been learned. But I'm also reflecting 4 or 5 years in, feeling that we weren't necessarily making strategic impact. That we can do wonderful one-off pilots and solve small pieces of the justice gap problem for single courts, but that idea of that leading to really changing those numbers of the number of people who are not coming to court, who are not being served, that there's a huge problem in that small pilot model in converting those big numbers to something that looks like the justice gap is closed. And this is the pushback I get from my colleagues at the law school is, yeah, this type of work is great, but are you really changing those numbers? Are you increasing the rate of people's participation? Are we reducing the numbers of filings that are defective or people who are defaulting? Are we improving the chance that people stay in their houses after getting an eviction notice from their landlord? These really meaningful parts of the justice gap problem. So that's where the challenge came back to me of thinking, okay, so we have this network of labs that are working this way, that are doing these human-centered design projects, going out and talking to people and building things and building these local coalitions. And many of them are working in the same way as me, doing one-off things, reactive to their partner's needs or agenda, making a project, launching it out as pilot and being like, great, good job, move on to the next project. How do we leverage this network of labs and this great way of working to actually get to impact? Because each project is so limited. Because oftentimes we thought, oh, we'll make a great text messaging pilot in San Mateo, and then every other county in the Bay Area will want this. And no, that's not how. Oftentimes we go to these conferences or we do webinars and say, look at this great text messaging pilot we have in San Mateo. Santa Clara, don't you want it? Alameda County, don't you want it? Contra Costa County, all of our neighboring counties. Similar population, similar problems. And the inertia is huge. Pilots don't scale to widespread impact. So people are like, yeah, that's great. Yeah, but I'm going to go back to business as usual now because I don't have a lot of funding, and it's great that San Mateo did that, but that's not our incentive to replicate. So there's where I am now thinking, and what I'm very excited to talk about is the second phase of work, where we take these kinds of human-centered design projects, but then layer that with more systemic and regulatory change efforts to deal with those constraints. So this is the second phase. Where thinking about if the past 5 years was setting the foundations for more access to justice innovation work, not just at the labs that I was talking about before, but also with the Legal Hackers Network and other efforts that have really galvanized a broader community to be involved in legal tech and legal innovation. Now I'm very interested in how we convert that community groundswell of interest in innovation into something that actually impacts people's lives for the better. So this is my pitch that I've been making. I had this slide in London in June where I was talking to a group of people who run labs like mine and basically saying, okay, we're all suffering from a syndrome called My Brilliant App syndrome, where we all build something and it is great, it is beautiful, and it is solving someone's needs in our local community. But it is not strategic and it is not that impactful. We fall in love with our own small little pilot, and we forget about the real indicators that we should be focused on. So how do we go from a My Brilliant App view of innovation to something where we are thinking about a person's problem and how to get them through the justice system, not just solve one little problem on their journey, but think about how we coordinate to solve all of those problems to get people from civil legal problem to resolution where they are hopefully insulated against negative outcomes. So this is what I'm calling on, and for any of you who are working on innovation, this is my call to you, is how we can work together to better establish common best practices, that we have long-term partnerships both with our courts or judicial agencies or legal aid partnerships, but also among the labs, and that we work together on coordinated, comprehensive sets of interventions. I'm really inspired by my colleagues in the US who have started a similar kind of coordinated innovation movement around fines, fees, and bail reform, especially after Ferguson, Missouri, and how that exposed how court fines and fees have really harmful impact on people's lives and their likelihood of ending up in the criminal justice system. Their network is now coordinating across the country all of the legislative efforts, technology efforts, service efforts, regulatory efforts to address the problems of burdensome court fines and fees. So they've built a clearinghouse to document what's going on, but also developing a cohort of cities, including mayor's offices, courts, and local advocacy communities, to figure out how to replicate what works well in other cities to their local jurisdictions so that good innovations can spread across the country. I was really inspired by this, and that's where I'm trying to develop a similar network around eviction and landlord-tenant problems. So this began in a similar way to the story I told you before about how we normally do human-centered design work. So again, we started off with a class at a university where we said, let's figure out the best ideas that we can come up with to address evictions and the problem of tenants who have very few protections when a landlord decides they want them out of their rental house. So we had a class, we researched what's out there and what could be, what are some interesting models. We developed some new websites. We worked with a jurisdiction in Arizona, Pima County, to help develop a website that the courts could host to help any tenant who received an eviction notice to show up to court with a magic script of words they could read to the judge that had their defenses and counterclaims. We did all the good design work. We did a lot of feedback sessions with tenants. We did high fidelity testing in the courts. Then we did a randomized control trial to see if this website was actually used and useful by people in Arizona. Guess what? It was not. And that's where I was really inspired we put basically 8 months of focused effort into this website. It's like a TurboTax-like product to help people deal with their evictions. We did all of the testing, all of the legal and regulatory compliance to make sure the courts could host it. We did a lot of work on it, and the randomized control trial shows that very, very few tenants, when it comes down to it, actually go to a website and spend more than 5 seconds on a website. They just are not in the mindset to do the equivalent of their taxes to figure out what their defenses and counterclaims are when they're facing an eviction notice. So that led us to the brainwave. We also sent them mailers. We, again, had used the best of social science research about different behavioral insights to leverage to get people to take charge of their case and to use the website and come to court and protect themselves. And we found very few people. In testing, it worked very well, but in practice, people were not opening that mailer and they were not coming to the website as we had been trying to get them to. So we presented these findings on a webinar. We were trying to be really honest about our failings. And the interesting thing is that another jurisdiction wanted to work with us, even though our initial pilot in Arizona, the preliminary results were all quite poor. Another county, Cincinnati, and the courts there in Hamilton County, Ohio, said, well, we can try again. Let's try a different version in Ohio. At least you were trying something in Arizona. I bet we can figure out what went wrong in Arizona and then come up with a strategy in Ohio to counteract that. So we got the court in Ohio. Before in Arizona, we were mailing out a flyer as a third party. So basically the day after a landlord went to court and filed an eviction notice, our law students would mail out a mailer saying, come, there's help. Come to our website and we'll help you with your eviction. What we got the court in Ohio to do was to put the advertisement for the website and a text message line right on the court summons. So it's coming from the court with the official logo. We found in Arizona that people didn't trust the flyer. They didn't say this in user testing, but they told us afterwards in the field trial, because it didn't have a seal on it, or because it wasn't from the court, they thought it was some kind of scam or spam or someone trying to bilk them. So now in Ohio, we're trying a different version, this time with a court seal on it and with referrals right on that summons. And we're trying a text message line rather than a website so that there's a lower barrier for people to access the help. So we'll see if this works better. But what that made us realize is that, especially if we as a university lab have the luxury of being honest with our failures or our initial pilot's failures, that we can then see if we can spread that lesson so that Ohio, which otherwise was going to spend a lot of money on a website, can save that money and now invest in a more informed strategic spend on something hopefully that will test better. We're about to launch this trial and I'll be able to see if this gets more people to come and seek help. We've also been working a lot more with technology companies like Google on what search engines, which we have been finding are a really key referrals, trusted authority, how information shows up on those Google search pages or mobile screens or Alexa-like products when people ask, I just got an eviction notice, what do I do? Or I need a restraining order, what do I do? So there's increasing interest from search companies about improving the jurisdiction correctness and issue correctness of the information that's shown on those screens. So we're working with these national or international search platforms to make sure that this information is really high quality and hopefully getting people to public interest resources. But all that's kind of the backstory to this vision of a more strategic network. So we tried the human-centered design efforts. We have some good forward motion and some lessons learned. But what really I'm excited about is that we can create a network of labs that are doing pilots and contributing to networked innovation. So right now, we are working on building a strategic network in the US and perhaps beyond on eviction innovation. So my student team and I are having so many phone calls with people who are leading different tech innovations, AI innovations, right to counsel and policy change innovations, reg reform innovations, document innovations, like anything that's about improving the eviction system. And we are mapping out how the eviction system works in different jurisdictions because, surprise, every state has a totally different set of rules and court procedure for how people get evicted or try to evict someone. We're also landscaping the 20 to 30 main categories of ideas that are out there for innovation. So trying to get a hold on what that menu, what innovation actually looks like. It's not infinite. And then we're coming up with the main scenarios, the main types of eviction, the main categories of user stories, litigant stories that happen in eviction. And all of this mapping is intended to lead to a network where we can all across the country in our different jurisdictions be talking about the same indicators, all focusing our efforts, those of us who care about access to justice, and especially those of us who care about housing and eviction, that we can be talking the same language, focused on the same indicators, but still doing local pilots and local evaluations to keep it contextualized. The goal is that we could work together to develop in the next 3 to 5 years a set of best practices. If mayors have limited budgets to address the eviction crisis, we should be supplying these agencies with pilots and programs that have worked elsewhere with detailed information about how things can get set up, what best practices are to run them, how much they cost, how much they save. We need to be doing this in concert to develop this evidence base and this knowledge base about innovations. We need to be doing a whole series of experiments. So instead of doing one-off pilots, we need to be thinking almost about a living lab model of courts where we are testing out all different types of interventions, everything from rules reform to document design reform to space and wayfinding to text message. There are so many things we need to be doing to solve this problem. And the other big layer of this is thinking about policy making and reg reform. So this is the other thing that I've been working on a lot over the past 2 years, which is thinking, because in the past, in my lab, and I think most labs, are most focused about program work. Because we're talking to people on the ground and litigants and frontline staff, we're really focused on the pieces of paper and the technologies and the in-person services and all of these really concrete things that need to be changed, at least in the US's justice system. And then there's a whole other world of people talking in the abstract about new rights, about new legislation, about regulations and markets. And honestly, for the first 4.5 years of my work, I ignored them. I was like, I'm just focused on like what pieces of paper people see or what the signs look like or what it smells like in court, like direct practical things, because of how important that is to a lot of the litigants. But thinking about strategy and impact, we have to bridge this divide of people who are working at the big, abstract, systems change level of policy work and bridging that to program work. And honestly, it's because there is more of that policy work that's getting traction in the US. Right now, right to counsel, especially in housing court, is really taking off with cities like New York and San Francisco, Newark, and possibly LA, instituting this new right to counsel, universal access to lawyers if you're going through housing court. And the programmatic implementation of those big new rights is really fraught because it's not easy to get those policies enacted, but often once they're enacted, there's a whole lot of work to actually make legal services accessible or to help people know about their rights or make use of it, or to coordinate the service providers who are now supposed to be providing this right. So we need to be figuring out how to link our big system thinkers, our policy makers, our folks who like to draft legislations and reports, to work with those of us who would rather focus on very practical, concrete things. But we also need to figure out how we create new policies or regulatory structures that allow more of this innovative work to flourish. And that's where I've been working in the state of Utah, which maybe you have read the task force's report from August of this year from Utah about narrowing the access to justice gap. So there's been a group of us, including Jillian Hadfield, who I think has spoken to this group or another group in Vancouver about new regulatory approaches and the importance of that for legal services. So Jillian and I and a handful of other people have been working with the Supreme Court and the State Bar of Utah to think about how regulatory reform could really drive access to justice in their state and beyond. And we're very inspired by regulatory experiments from financial services sector. And this is where the idea of a regulatory sandbox comes in. It really grew up in financial technology sectors in UK and Singapore and Australia, now in Arizona, and actually Utah just adopted a resolution to have a fintech regulatory sandbox. Let me do another poll. Who here has heard of a regulatory sandbox before? Okay, better than most crews. So the basics of a regulatory sandbox are on this diagram, but I will repeat it just in case. It's essentially a way for a regulator, let's say the Supreme Court of Utah, to say, hey, are there any innovations out there, new services, new technologies, new things that could be serving our Utah consumer public, those members of the public who are interested in needing legal services, but the service providers are worried that they might be targeted with a regulatory action if they put their services onto the market. Maybe they have a robot lawyer or a new staffing model, or they need to take investment from an outside group. And they know that if they do that, that they might have a regulatory action against them, and thus they have been chilled from innovating. Instead, let's open a sandbox. Let's open a controlled setup where a regulator says, hey, innovators, do you have something that you think actually will help the public, but the current regulatory setup, the current rules, would mean that you are facing regulatory action? Guess what? If you can prove to us that your new thing helps people and doesn't harm them or cause major risks, you can exist in our sandbox. As long as you give us data that shows us that you are helping the Utah public and that the Utah public actually wants your new thing and benefits from it, and you are not causing them harm, then you can exist. And we will give you a non-enforcement letter that says that you will not face regulatory action from us. And then at the end of our sandbox cohort, which could be 1 year or 2 years or 3 years, so whatever the regulator says, if you have shown that you have a new innovative thing that people want and that does not harm people, you will get a permanent letter of non-enforcement. So you will be able to exist after the sandbox. So that's the basic idea of sandboxing that grew up in financial technology. Utah, in its report in August, which I invite you to read, has said that it's going to go ahead. The Supreme Court is going to launch a regulatory sandbox where basically any of the professional rules that govern lawyers could potentially be relaxed for an applicant who can demonstrate why it needs that rule to be relaxed. It's also proposing a new regulator that at the same time as a sandbox is set up to welcome in new innovators, new service providers, new firms to offer stuff to the public, the Utah Supreme Court is going to prototype and test a new regulatory body that's separate from the state bar that would oversee this sandbox and have a different kind of relationship to the organizations it's regulating, one that's much more driven by data and empirics. So asking the groups that it's regulating for data about the harms or the benefits of its products, of its services, and that will have much more capacity to do that kind of auditing or data analysis. Right now, we're in the middle of setting up and designing and putting all of the specifics on this sandbox and this regulator, so I can't talk too much more in detail. We'll have more updates soon. But you can read the August report to see the basics of what the Supreme Court has set out as the vision of what the new regulatory sandbox and regulator could be. As a human-centered designer and a lab runner, I'm very excited for this because honestly, many of my students who I wish would take more risks with the wonderful products and ideas that come out of my lab or their labs in Utah, there's not really a clear path for a young law student graduate who has an idea for a wonderful new technology product or a new way to run a nonprofit law firm or other kinds of public interest business models. The goal with the Sandbox is that they can enter this and in a controlled ethics and consumer protective way, try out a new business model and potentially get investments and support a trajectory to actually build a new type of career or a new type of service in the market. So I'm very excited about that as a way to hopefully promote more public interest-oriented services in the marketplace. We see other states also interested in regulatory reform and sandboxes, including the state of Arizona and California. I don't want to make it too US-centered. So that question just begs, as we have more sandboxes and more reg reform, I know there's plenty of profit-oriented big corporate law firms that are ready for these kinds of new sandboxes and new openings in the market. I'm really interested in how we also get smaller law firms and public interest-oriented law firms and firms that are going to serve the folks in the current justice gap to also be a part of this big new regulatory shift and this new type of marketplace. So I'm almost done. I'll just say, how might we work together? I'm really interested in thinking about beyond the US borders. I'm talking a lot to folks in the UK and Australia, and clearly there's a lot happening in Canada too when it comes to legal tech and access to justice innovation. I know our legal systems are different enough that it's not that eviction is clearly as big of a deal, big of a concern as it is in the US right now. But if you are happening to be interested in housing and landlord tenant and evictions, let's talk afterwards. I'd love to hear in the Q&A section if you have questions about regulatory innovation or thoughts about how that translates to Canada, or if there's already things bubbling up here. And also if you have a sense that there is a possibility for a network of labs in Canada or a cross-country network of labs where we can be doing research and development in concert. So that's enough for me. I will say thank you and open it up for Q&A.
Thank you very much. If you have a question, would you please come to one of the microphones so that those who are participating by webinar can hear your question, and then we can have Professor Hagan respond to that. I can see the wheels turning in the minds of many people who are thinking, I'm going to follow up on that. I need to ask a question. So please come to the microphones and ask those right now so we can all hear the answer to those questions.
Not so much a question, but just a thought. Maybe we don't have the same the eviction problems, but I don't think a problem in one area. There's ideas in your solutions that could help another area. So I don't think we should close our minds to sharing experience.
All right, I'll break the ice with a question. Forgive a bit of preamble, but my actual paying job is as counsel in the tax world and dealing with tax disputes. Mm-hmm. So when I picture the groups of different stakeholders sitting down in some of your early pictures, and I picture the folks on either sides or the various sides of tax disputes, my perception, and maybe this is unfair, but my perception is that there are players who are so far removed from each other that being willing to sit in a room and be cooperative can be challenging. How do you get past those sorts of impasses in just starting that brainstorming development?
So I'm not a tax law expert. I don't presume to know the client stories or the different points of view, but we've been working a lot in divorce. I was focused on divorce several years ago, and there we took people who were at a minimum 2 years out of the court system past the resolution of their divorce, and then recruited people to come back and do these kinds of design, mapping, what was your story like once hopefully the tempers had cooled, and it's not like we had people from the same case in the same room, but we made sure we had different types of litigants from a divorce process in that room. With the goal, I mean, this is the tricks of design facilitation, or the ingenious things of design facilitation. How to get people who typically speak in different jargons and coming from different points of view to be focused on a constructive frame of what could be better. Like, if this is your chance, you group of stakeholders, to tell people with money and power what could be better, let's do some exercises where we're all looking at the same surface and we're all able to tell our story and have validation of our points of view about what could be better. So that's where working in a design kind of way, in most cases, can get people to talk coherently to each other. Of course, there's always hierarchy and some amounts of dispute, but you'd be surprised about what people will do, especially if they're in small groups, how they are able to, I mean, we've even had like very esteemed and somewhat cranky judges kind of come off their typical pedestal and join in and be able to really, oftentimes judges come in with an idea that they know all the answers. So I think the design process is trying to get more people to be able to counter and defend and kind of debate what actually is the priority. And so we often are able to get people off of their pedestals in this kind of way. But it's not always perfect. We oftentimes have people who wish they had more of a say than they end up having when they're in a big group. I can't tell you the perfect answer, but
So there's a question online. Any thoughts on what we can or should do to reach potential users? That is, people who may not perceive their problems as legal, bearing in mind Becky Sandifer's research, which has similar results in Canada.
Yes, I've been thinking about this a lot. I think of this almost as the engagement gap, because this is the other issue that I see a lot with the legal innovation and lab approach, is that we build lots of things, very promising and beautiful new websites, new apps, new materials, and very low usage rates. And I've been involved in these projects too. I'm very honest about it. There, I think we need a whole other strategy of community involvement, as well as search engine and digital outreach platforms. So for the community involvement, that's where I'm thinking a lot about how to get more co-location of legal services, legal outreach into schools, churches, libraries, other places where people might be talking about their problems to another trusted person, and how we can have legal services or legal referrals woven right into those other discussions of problems. So that's a very like city by city challenge about where those trusted places are. When I was working in Pensacola, Florida, right near the border of Alabama on the Panhandle, that trusted place was evangelical church services on Thursday night at 7:30. That was the place to put services. And we figured that out by talking to people and having them literally map out where in Pensacola they would put a legal clinic or a pro bono attorney or somewhere else. So talking to people helps a lot in finding where that local community center or trusted relationship is. For online, I think the equivalent needs to happen, especially with the new generation, the millennials, the Gen Zs, whatever it is. We know that more people are going to search platforms to figure out, if I have a problem, what options do I have? What even is this problem called? Is this a thing? Can anyone else tell me how they solved this problem? So that's going to the search platforms, like I said, with Google or Bing or Alexa or Siri. So the 5 big companies, maybe even Facebook. It's also going to places like Reddit and Yahoo Answers. I see a lot of people going to forums rather than going to official court or legal help websites because they want to story match. They want to basically crowdsource of all the people who are like me, who have been in a similar situation with an immigration visa problem, or with a divorce, or with a dog who hurt a neighbor's kid, whatever it is. Those platforms like Reddit have a huge volume of people's stories so that you can find someone whose story matches yours, and then you can try to learn from them what they did. or ask the crowd and get the crowd to comment and tell you what to do. So we see a lot more of this activity of people trying to go through more peer-to-peer kinds of relationships to diagnose their problems and to find help. So one of the projects that I've been involved with a collaboration with Suffolk University in Boston and David Colarusso's lab there, has been about Reddit in particular. And we've been developing a machine learning classifier, a little computer program that we have been training to be able to spot people's issues. So when it sees 5 paragraphs or 1 paragraph of a person's story on Reddit, this little computer program can classify, this seems to be a family law problem. And gradually it's going to get a little bit smarter and say this is a family law problem and it's a divorce problem and it's a divorce problem involving kids' custody, but starting to kind of get it to what legal issue is particularly there. And the goal there is that if we can get a computer program to spot legal issues, we can also get it to provide referrals to local jurisdiction-correct, non-peer-to-peer resources. So like the local self-help website or the local law portal or other kind of official correct legal information. We're still not sure if people actually want that. We see a lot of people actually still want to stay in the peer-to-peer informal realm rather than go to a more official realm. So there, some of our thoughts have been around how do we basically astroturf and like the hackers in the 2016 election, how do we pretend to be a peer but actually have like correct legal information like that would show up in people's comments? But if our worry on these peer-to-peer websites is misinformation, how do we use that to get correct legal information out to people? So we just need to be more creative, and we need to be a lot more culturally sensitive about how people like to share their stories and receive advice and information. A lot more work to be done on this channel.
Professor Hagan, my name is Jennifer Brennan. I'm a civil litigator in Vancouver. I'm also the vice president of the BC branch of the CBA. I just wanted to start by thanking you for this incredible, thought-provoking, and inspiring presentation. I actually have 2 questions for you. One was you mentioned the self-represented crisis that you have in relation to evictions and the housing needs. And we have a similar issue here, as I'm sure you can appreciate, in particular in provincial court and in family law matters. And I'm wondering if you can share some insight into how you did ensure access to counsel, if you have any advice on that.
So ongoing process, I would say some cities are focused exclusively on right to counsel. So a lot of cities, I think eviction rates across the country are high, whether it's in coastal cities like San Francisco and New York, where the housing markets are crazy, probably familiar to you, or it's more middle of America cities that don't have out of control housing markets, but it seems like boom times, post foreclosure, post 2008, now eviction is really taking over as one of the main concerns that the civil justice system is driving people into poverty or homelessness. So just that there's a lot of cities experimenting. Some cities are devoting most of this interest and passion to the right to counsel, which means getting a legislature or even the US Congress to pass a bill and say, it is now guaranteed, or it should be guaranteed, everyone who either falls below a certain income eligibility line, or maybe everyone who goes to housing court as a defendant is guaranteed a lawyer. That's great, that's very exciting. We do not have, in the US, the ability to serve everyone who needs a lawyer. Like there's just a huge gap in the number of lawyers in housing who have specialization in housing law and landlord-tenant law to be able to serve all these people. So that's where we see a lot of growing pains in cities that have right to counsel. That's where I'm excited in these coordinated sets of interventions. So not just rolling out a big, exciting new right to counsel bill, but also working on how we staff and train and run technology-wise nonprofits who are serving people with housing needs, that we need to be able to radically scale up how we do this kind of work, potentially have a lot more of these consultations online through virtual means or text message means. perhaps change how we staff things. If we don't have enough lawyers, how do we train other people who can be housing court navigators or people giving guidance? How do we let some tenants do it themselves? We just need a whole coordinated set of solutions, from new technologies to new services in coordination with their rights. I don't see any city yet doing that. That's why we're building this network to get more of this. You can see some really interesting cities like Philadelphia, where the mayor's office actually took charge of the access to justice crisis. And it was the mayor's office who put together a strategic plan of about 12 different interventions to do. So everything from getting more money to people who need money to make their emergency rent, to new navigators in the court to explain what the heck is happening, to mediation programs and things to help settlements become more fair. So I think the mayor's office was actually really instrumental in getting access to justice innovations bubbling up and actually deployed. It's interesting to see who's taking charge, whether it is a government agency or the courts. I'm really excited, though, to see these networks that are trying multiple pilots at the same time. Sorry, I'm just talking at this point. I'll stop talking.
That's all helpful, thank you. The second question I have is with respect to the regulatory sandbox that you mentioned. And I'm curious, I take it that this is sort of early days as far as the legal profession is concerned, but do you have any success stories from the UK or Australia or the US with respect to the regulatory sandbox in the legal realm?
So short answer, no.
Okay.
I think there's lots of success stories of fintech sandboxes, which is why legal is now borrowing the model. So I think the success story model from fintech is now we have new technology-powered, affordable consumer services out there for people who need robo-advising or other kinds of new types of apps on their phone to manage their finances. Kind of good things for the consumer, that they have more control, more transparency, more ways to take care of their financial services needs without any major harms that have emerged. So that's where I think why the UK is working on its innovation sandbox and why Utah is now designing a regulatory sandbox. So we will see. But yes, it is very early days for legal regulatory sandboxes.
Thank you.
Mm-hmm.
Another question from online. How would you recommend implementing these changes with older populations, such as lawyers and potential clients that are used to the older systems? And to be clear, we have a number of students in the room. I've asked them to preface their question with their name if they're comfortable doing so. So this person's name is Emma.
Okay. So I'm not exactly sure the context. I'm guessing we can't have a back and forth. I'm guessing they mean, I'm not sure exactly what they mean by implementing the innovations. This is sorry, my brain is running out of steam and I don't want to make any generalizations. Can I pass on the question? I'm not sure I can answer it. I think it's so contextual to the type of law or the type of people and the type of innovation, so sorry.
Here's a second question. How is the Utah Bar reacting to your regulatory sandbox initiative? Would you please comment on how you are working with the bar?
Sure. So we have been working with the bar very closely. I mean, members of the task force, we have 2 former heads of the bar on the task force who have been instrumental in writing the report. We have been taking the same approach as I've talked about, a design, participatory design approach. So running workshops with the bar about how relaxation of the professional rules might create risks or harms, to kind of flesh out some of the scenarios or worries they have, risks that they're thinking about, and then to use those findings from the workshops to then inform our design of the new regulator or the regulatory sandbox. We've had another kind of workshop where it's about, if we did have a sandbox, would you come? Or what kind of business models would you be interested in testing out, with the goal of figuring out how we can help them make the best use of this new change, and hopefully use this opportunity of the sandbox to figure out new business models that might be of benefit to them, especially for solo and small firms. Because we know that the corporate law firms are more ready for this change. So we're very interested and we'll be having more of these workshops to help solo, small firm, and public interest actors to kind of get ready for possibly submitting something into the sandbox. We've had public-facing meetings where a week and a half ago, we were in Provo, Utah, and members of the task force had our report, presented on what was in the report, and then opened it up for the bar to tell us all of their concerns. Several of the concerns were about commoditization of the law and worrying about how healthcare models, business models in the US might crop up in the law, where we have more business-oriented folks who now run legal businesses and then basically burn lawyers out by treating them as cogs in the wheel or trying to squeeze every last drop of efficiency out of lawyers. This is all really useful thoughts and help as we design and try to measure the regulatory sandbox and the regulator, because we want this system to work for lawyers themselves, and we want lawyers to be a part of this, and hopefully they will be coming up with many of these new business models, new staffing models, new tech models, so that the professional values that they carry can be part of the innovations that are being tested in the sandbox. So our goal is to work as closely with them as possible. And the sandbox is a controlled experiment that we hope that they also make use of.
Hi, thanks so much for your presentation. I really enjoyed it. I wanted to ask a question about the coalition that you're working on forming. So you have a lot of different people and from different backgrounds involved in working together, and I was curious how that's going, or how you're making efficient use of time and kind of reaching common objectives with all those people.
About housing, about a housing network?
Yeah.
So I have a core team of wonderful students, and we are calling lots of people who we either know, have been recommended, or we found about on Twitter or found about online. Everyone is similarly motivated around the same indicators, around the same problems of eviction and landlord-tenant issues, about the system not being sufficiently accessed by the people who are in most need of protections, and of people's life outcomes really suffering and the community suffering because of how the court goes. So we have that unifying set of concerns and problems we're trying to solve. So even if we come at it with different professional backgrounds, legal, technical, policy, city government, I think there's a lot of unity around the same purpose. And honestly, this book, Evicted by Matt Desmond, really crystallized a lot of these conversations. So everyone has read that same book and can reference that as like, do you remember that story in Evicted about what happened in Wisconsin? That's what's happening with us in Philadelphia, and this is also what we care about. So somehow there is this touchstone of common problems and this common understanding of the frame. That means we haven't had that many, we get in sync very quickly. Even if we talk to, lawyers who have been working on right to counsel and very passionate about right to counsel being the only thing that matters and everything else is less than, I think we're all still framed around the same common problem. So that's helped a lot. Honestly, it hasn't come up. We're still early days, so we're all still talking to people who have already opted in to trying new things out and piloting new things. We'll see how that goes, if there is. Do you expect there to be any certain types of problems?
I don't know. I work at a nonprofit, and I work in a lot of coalitions, and when you mentioned spending time on the phone, I spend a lot of time on the phone, and don't always reach where we hope to that as quickly as we thought we might. So I was curious how you bring people from such different perspectives together. And
I don't think we have different perspectives yet. We're not making decisions yet. We're not trading off resources yet. I'm sure if there is a resource allocation meeting, then we will have more consensus issues. But when it's trying to figure out what are the top 20 or top 30 really great ideas, most of the people we're talking to are just eager for anyone else to care that they have been trying something out in their city and that someone will be making use of that somewhere else. So that's the current mode of our strategic network, is just people being like, someone's talking to me, that's great. I've been like so heads down on my own community that it's like coming up for air. So that's kind of the happy early days of the network. We will see what happens and that's also why we're taking an approach where we are not trying to own it as Stanford. We're really cautious about how this thing becomes a thing and how we keep it non-hierarchical, but still with some core of people who are doing work and putting out product and making sense of it all. So we'll see more as it becomes more of a thing or more institutionalized. But right now, there's not that many power discussions yet, so we'll see.
Thanks.
Professor Hagan, Margaret Marai, CBA BC past president, thank you and welcome. The question I have for you is taking back to the question you spoke to earlier of a user in the system being able to identify a legal issue. I'm curious whether any of your design work has focused on the point of the transaction, the legal transaction, whether it's entering into a residential contract to rent or whether it's the purchase of goods. Is there anything that can help educate and inform at the point of the transaction that these are potential scenarios that could go wrong and where could you go? Has anybody looked at that?
So there's a lot of work, not surprisingly, around privacy policies, terms and conditions, consumer contracts, and how we make that contracting moment more of an educational experience or something more preventative. I don't want to say I wasted 3 years working on this, but it feels like I did. Guess what? People don't want an educational experience while they're in a transaction. They want the transaction done. So I still am following this discussion because GDPR obviously has been huge for privacy business in general, but including privacy design and consumer contracting design. So there are a lot of well-meaning, beautiful terms of service that have more icons, more links, more layered information. And there are certain design patterns that have really emerged in the privacy policy or consumer contract space that is about getting those people who do want to have an educational experience at the transaction moment to have clear, plain language, diagrammed information. So for that small percentage of people who do want to read some amount of fine print, that they have resources that are more comprehensible and less like a giant legalese glommed on like 500 contract. What I have seen that has some promise is an ongoing contracting experience. And Facebook has a lab called Trust, Transparency, and Control Lab. And they've been working on kind of an ongoing contracting experience. So let's say that you sign up for a service like Facebook or Uber or Spotify, and you agree to the terms and conditions up front, like any good citizen on the internet. Then as you are actually in a scenario, like getting into an Uber or deciding to share something with Facebook friends or making something public on Spotify, that they bring up some of those terms again. Or say like, we know that this might be of concern or this scenario, we think you should actually think about this scenario at this point because you are making a choice that might have some concerns for you. So we're gonna bring up these clauses again and maybe present you with an opt-out even here or just make sure that you know what you're doing. So having these kind of like ongoing refresh, hopefully when you're making a decision and care more about these terms, that they apply more to you. So that's one of the hypotheses that's going on. Another one, I talked about this with a few people here before, is how to have a contracting platform that maybe even at that golden moment of you signing a contract with your landlord, your employer, your contractor, or any other day-to-day contract you sign, that you are on a platform that records that contract, but it also lets you record more details and future evidence about payments that you've made or they've made or problems that you've documented, questions you've raised. But it's all on a platform that you can then pull in a mediator or some other third-party neutral or even a court to then see this relationship from the contract through good times and bad times and problems and documentation of evidence and payments. So something that like reinforces that, because I think at the start, it's a really hard moment to get people to have an educational, thick experience of law.
Absolutely, and they may not want to read through it, but is there any way to sort of say, this is some information and a link that they then know to go back to?
You can definitely do it. I mean, there's been a lot of money made on GDPR-oriented products that give executive summaries, icon summaries, layered things, links. Still, when we actually user test these, there is so little demand or usage engagement of these. And it might be different in EU or places where the culture is changing to be more privacy focused. But in US, even with law students, we have a really hard time engaging people at that moment in legal understanding.
Thank you.
So there are 3 questions online.
Let's go for it.
Okay. So following up from Emma, the question about implementing changes was in reference to general situations where lawyers and others have to use technological resources that they may not be used to. Any tips on how to encourage uptake amongst hesitant participants?
Can I crowdsource this? I really don't know the answer to this question. Anyone have good thoughts about how to get people to use technology that they might not want to use? Or be able to afford it.
All right.
Sure, go for it.
Well, I guess I would say that even grandparents FaceTime with their grandchildren. Oh, I'm sorry. Sorry, I was just going to say that I guess even grandparents FaceTime with their grandchildren. So if you can make it user-friendly enough, I'm not sure that this is a really fatal problem.
All right. So the next question. I work in environmental and natural resources law. Do you know of any trials or experiments with different access to justice models regarding environmental or land use issues?
No. I mean, I do see a large, what's happening in the US in my backyard right now at Stanford and elsewhere is climate change, policy design, legal innovation. And there's this growing movement of disaffected lawyers and former bureaucrats who have tried to use the UN as a channel or tried to go into government service to think about big new regulatory changes for climate or how we measure risk or how we get people who are buying homes in California to understand the risks that they're taking on and climate insurance. And there's lots of different variations of this. So there is this bubbling up of design approaches, climate change issues, and law and bureaucracy, regulation, policy. All that means is they're talking to each other and trying different experiments and going to the UN and trying to run different kinds of sessions. I haven't seen it documented or tested, but at least there's this kind of movement underway, similarly in Australia. But I haven't seen it coherently described or lots of evaluation of it.
Okay. And are the solutions or products that you have designed in your lab and networks proprietary? Are there any opportunities to share this technology across the border here in Canada? For example, the AI that you've been working on to analyze people's legal questions on Reddit. How do we collaborate with you if we're interested in your projects?
We're very open source. The model is a little bit difficult. We're thinking about this, and this is a broader issue about data, privacy, algorithmic fairness. So we are building this model. The Pew Charitable Trusts is our main funder. Suffolk University's LIT Lab, Legal Innovation and Technology Lab, is the group that's responsible for building the model. My lab was responsible for building the application it's a game called Learned Hands, you can go check it out, to get people to be labeling things to train the model. We're all working together. The model is online right now in its, I think, April 2019 state. We can see if we have a more updated model, so very happy to use that. But I think right now we're reckoning about possible community harms and benefits of having a model out there that can predict people's legal needs. How can this be misused by actors who are not necessarily interested in the public interest? Can it be used to target people and sell them bad products or in other ways harm them? And the same thing with the underlying data that we are using to train these models. So I'm very interested, if any of you have any interest, in data trusts. I know it's kind of hot right now in Toronto with Sidewalk Labs and all of the data that's being gathered and analyzed in that smart city effort. But we need, as we start venturing into emerging tech and all this exciting AI models that can be used in the public interest, to think about plans to protect those models, protect those data sets, and hopefully use the value that can be created from them to benefit the community whose information and data was used to create these new models and technology products. All of that's to say is it is open source and we are interested in collaborating, but we're still very cautious about what open source means when it comes to data and models and how that can be misused. But they should talk to me, yeah.
Hi, my name is Angela McHugh. I do some strategic public interest litigation, and I'm also interested in law reform, work in the environmental area, and also a person with a disability and work with some disability organizations. So I have two questions. The first is, as part of your landlord-tenant program, do you gather information about how the people came to have the eviction issue? About, is it a family law problem? Is it a disability issue? Is it because you have a criminal record? So that you can actually get at some of the larger, yeah, exactly, and reform the law that causes the issue in the first place.
So we're really interested in this, and we've just been, so I'm teaching a class on this at the same time as we're doing the network building. So we've spent the past 2 weeks just talking to 10 to 20 tenants per day about what their story was and how the upstream to the problem and the lawsuit to the downstream, the whole story. And we are seeing this huge overlap of family law and relationship issues, especially downstream, how many of the people who we've heard their eviction stories end up breaking up or divorcing in the months after. Same thing with mental health and suicide risk. So that's the downstream. Upstream, a lot of it's employment-based, gig economy factors and systems, Airbnb and policy around short-term rentals, like that regulatory scheme, as well as criminal justice experiences. So that's from our limited sample of under 50 people in our backyard. So we're using this and our conversations with the other actors at this kind of national level to hear from them what some of their hypotheses are about what are these overlapping systems and factors. And then we're thinking about a survey or some other way to get a much larger sample size to hear more people's stories, and hopefully have done enough homework that we can make the survey capture as much of these overlapping systems or kind of upstream or downstream overlaps as possible. Because this is also really interesting and persuasive to get more people outside of law and civil justice to care about civil justice as we show to other government agencies or foundations about how interlinked these systems are. We start to get a broader coalition of people who could be interested in funding and working with us. If you have other thoughts.
Well, I was just going to say, it sounds like, yes, you're on it. And as someone who does public interest litigation, I'm always looking for where's the push for law reform, where's the place that if you were to bring a lawsuit that you could make a difference that multiplies in its benefits. So that's where my interest is, and I will follow what you're doing with interest. My other question has to do with people with disabilities, and I was just wondering as you were talking what efforts there have been to address accessibility, because many of the self-help clinics or other resources or places that you would interact with people may not be accessible to many people with disabilities, and there may be other ways that they would have to interact or reasons that they then don't interact. So I'm just curious about that.
So I think it's woefully not a priority right now. I mean, I see a lot of work, including some of my students have done excellent projects on web accessibility standards for self-help sites and at least getting the online websites and chatbots to be accessible to those with visual impairments. There's not, I would say that this question and the question of language access are often put to the side as something to deal with after the innovative work is done. I'm really interested in how we put those at the forefronts, especially borrowing from design procedure or design process. Oftentimes it's designing for people who are called extreme users or people with extreme types of user requirements, like who absolutely speak not a word of English, that you can actually come up with the best type of contract or self-help or thing that serves the general public, but focus on someone with a very strong constraint. So there just needs to be more work on this. I would love to brainstorm with you about how we could do it. because I think it is about setting that agenda as there are more labs to then put that at the forefront rather than as an afterthought.
Well, maybe talk to you afterwards and get some contact information. Thank you.
Yeah.
Hi, my name is Mina Blagojevic. I actually work at a self-help center with the Vancouver Justice Access Center, which is part of Ministry of Attorney General. We have 4 different locations: Vancouver, Victoria, Nanaimo, and Surrey. So I do work with quite a few clients that cannot afford a lawyer, have social and economic difficulties, may have mental illness, may have brain injuries. A lot of them find going to court anxiety-driven or bring on quite a lot of stress. And even when they come into the self-help room, they leave knowing something, but then they walk out and they forget because of all the anxiety. So my question to you is, through your projects, if you have collaborated with any psychological or educational professionals that can help find the best ways to educate litigants when they're going through these kind of mental illnesses.
So I don't have the perfect answer. I would say there's a wonderful professor at Indiana University in Bloomington, Victor Quintanilla, who's at the same time as he's a tenured law professor, he's also doing his PhD in social psychology. And he's been working on self-represented litigants and different social psychology, understanding what the process of being an SRL is, and not necessarily focused on people with explicit disabilities or mental health issues, but just talking to a wide range of litigants about being self-represented and what kind of status or roles you play and the social psychology of that. Now he's also thinking about interventions, because much like we see in the education system, where people can be very stressed, high performance, conversations, exams, other types of settings, there are many promising interventions in education about how to help students reframe stress or to reorient themselves in a really difficult process that gets them to feel more dignity, more belonging, more confidence and capability. So that's one of the working hypotheses, is that self-help centers, legal aids, and courts, if they took a more social psychology approach to litigants, could be figuring out ways to build their capabilities and sense of empowerment. It probably won't work for everyone. It's not like a treatment plan. But it is about trying to understand this experience of being a self-represented litigant and how stressful and the lack of respect and dignity that people feel when they're going through the process. So I'm really excited about that. But I don't have any, I'm sure you have more ideas than I do about this. So,
thank you.
So I have this question, and it has to do with the law itself. We always talk about accessing justice, and there's a lot of people in this room who are interested in how do we get citizens to interface with the law. And I'm just wondering, and it's more out of interest, I don't have a particular feeling, but is there any work being done on applying design thinking to the way laws are written or done, such that there's some integration between the two, as opposed to like, here's some legislation, kind of like deal with it, basically?
So there are some digital versions that are interesting, and I am trying to remember off the top of my head what they are called. I can't remember. There were some really interesting kind of nonprofit startups that were aimed at participatory democracy on a draft piece of legislation, how to have notice and comment that was more interactive and hopefully not trolled, but to have lively discussions about what this word or phrase means or what should be changed. It was collaborative editing of legislation. I haven't seen that necessarily pay off in a big way. They were more prototypes or pilots that were of interest, but honestly too easily trolled by online crowds. What I have seen really interesting is from New York University, NYU's GovLab, Governance Lab, GovLab, where they've been, actually it was a model from Poland about, I can't remember what the Polish word is, I'm not good at Polish, but it was a way of talking about new policy issues in an in-person, like a Saturday event where in the morning time, the community would get educated about what facial recognition technology is and how it works. And forget the misinformation. This is this new thing in our society. Let's learn about it and understand it and its dynamics. Now in the afternoon, let's reckon with it. Let's think about policies and what we care about, harms we're worried about, good scenarios we want to encourage, ways it might be misused, etc. And then come to some kind of proposal or set of requirements, if not draft legislation or policy. But like within a day, have these like small community policy making sessions. Like that. Now the GovLab is thinking about doing more of these for technology design across the country, which I think is really interesting, because oftentimes when I go to these kinds of like facial recognition technology, what should we do? You have very strong advocacy groups who say that they're representing the public, having very strong positions about what should or shouldn't be. And then you have institutional actors who are freaked out by how intense and political things are. It's not necessarily constructive. So I think that Polish model is really interesting to think about educating. And we see similar things actually with smart cities, where there's a lot of collaborative policy making. Like Georgia Tech has been running these local things around the city of Atlanta, where again, they get groups together in a neighborhood and say, hey, what if we had like 5G network data lines? What would you local residents of Atlanta be able to do with it? What are you worried about, et cetera? And then using that to inform the mayor's policy making around big new tech projects. So of course, that's not necessarily scalable. That's a very local kind of government kind of design process, but I'm really excited that it does seem to be more participatory and getting to like real policy making. So that's my short answer, long answer, yeah.
So on behalf of all of us, I am sure you are thinking, that sounded familiar, that's a new idea, oh my goodness, I'm inspired, I want her brain. I'm sure you're saying that to yourself, but thank you so much for coming and sharing everything with us today. We very much appreciate it. And again, on behalf of all of the organizers of this event tonight, I want to thank those who joined us by webinar, particularly the students attending at the hubs at the law schools, and all of you in this room for taking the time out of your day job to then think about these big picture issues and actually care about doing something differently. I want to thank you for your time, and we look forward to the next gathering that we have where we're stretching our brains a little bit more. The reception will continue for another half hour. Professor Hagan will be around away from the lights. Perhaps we'll allow her to sit for quick little chats. And again, thank you very much for tonight.